Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very good morning. Welcome everyone. Thank you for joining us for today's webinar. My name is Suhaimi and I'm from ABAC Center of Excellence. Today we are presenting an interesting topic titled Reporting Bribery and Misconduct in the Workplace. Know how you can be the whistleblower. Right. Yeah. Just a little bit of housekeeping before we get started. I would like to share a bit of about our house rule. Number one, we humbly request you to disable your microphone and then, if possible, also switch off your camera. This is to minimize the use of bandwidth so that we have a smooth session today. Yeah. Number two, please note that this webinar will be recorded. Yeah. Recorded, and the purpose is really for us to have it documented, and maybe later inshallah we're going to have this for you to revisit and look about and revisit the video and think about what have been will be shared by the presenter. Okay, if you have any questions, do drop your question in the chat section. Yeah, right. For a bit about the agenda for today, we're going to have two of our distinguished speakers to speak. They are with us. They are now with us today, Tuan Haji Nur Rahman Samingan and Dr. K.M. Lui. Yeah, so we're going to have the session from 10 until 12 p.m. Then we'll stop there, and then I'm going to bring in all the questions and for us to share, inshallah. Yeah. Yeah, that's about it. And then we hope that we can stop some before 12:30 so that we have ample time for everybody to have lunch, and some of us need to go for the Friday prayer. All right. So good news. At the end of this session, you will be getting an email of the speaker, contact details for further Q&A. Maybe you have some question or something for you to discuss. So we will share with you. You also will receive a complimentary voucher of 100 ringgit to join our ABAC whistleblowing training, and then we'll have the access for recording of this video. 1 week after the event, we will provide you with a COA and then also a CPD certificate. Wow, CPD certificate. And furthermore, we'll give you the educational ebook on the ISO 37002 whistleblowing. Okay, we're supposed to have welcome note from Mr. Zafar Anjum. He's the founder and CEO for the ABAC Center of Excellence and CIR Group. Unfortunately, he was not well today. He sends his regard and apology to everyone. Apologize to everyone that he couldn't make it for today. We hope and pray that he will get well very soon. Let me introduce you for our first speaker today. It's going to be Tuan Haji Nur Rahman Samingan. I think almost everywhere that I go, everybody recognize him. He's a very familiar face. Talking about whistleblower, talking about anti-bribery. So currently, Mr. Tuan Haji Nur Rahman is the MAC Senior Assistant Commissioner and Head Private Sector Branch Community Education Division. He read law from the International Islamic University from 1999 until 2002, later joining the Anti-Corruption Agency, now became MACC in 2005. He has vast experience as an investigator and a prosecutor. Wow, that's good. Okay. From 2005 until 2014. Now he's currently attached because of his wide knowledge and know-how. He's given to attached with the Community Education Division of the MACC, right? So he'll be here and there, almost everywhere, to talk about business and to engage with business entity, corporation, private companies in cultivating anti-corruption awareness. Tuan Haji Rahman, selamat datang. Thank you for joining, Tuan Haji Rahman. Yeah, I hope he's here.
Mr. Soimi.
Alhamdulillah. Thank you, Tuan Haji Rahman. Yeah, okay, I'm good. Yeah.
Alhamdulillah.
Okay, so we have another presenter with us today, another well-known and distinguished speaker, Ms. Dr. K.M. Lui. He's the currently president of the Association of ABMS Practitioners in Malaysia. He was a VC for ISO, VC 274. I think it's a project committee which was responsible to design, develop for ISO 370 ABMS, ABMS, and he also expert in whistleblowing management system guidelines. So he has a long-standing background for anti-corruption advocacy since 2000, and he has served as the deputy president from 2015 to 2017, and before that he was the Secretary General of ITI Malaysia and VC Chair of the UNCSC Coalition 2015 and 2000 until 2017. He was and still the UNDP PSAG advisor for the Fair Business Environment 2018 until next year 2022. Welcome, Dr. KM Lui. Doctor, are you okay? Are you with us?
Thank you.
Alhamdulillah.
Thank you.
Good. Thank you.
That's
Okay. Good. Very good. Thank you. So I think times is about should be 10 time we should start now. It's going to be a bit late. If we wait much longer. I hope the listener, if you have any issue, please use the chat section to ask question or any issue you want to share or any thoughts. Yeah, by all means. Without further ado, I'll turn the time over to Tuan Haji Lokman to start with his speech. Tuan Haji, the floor is yours, Tuan Haji. Thank you.
Whistleblower. A person, usually an employee, exposes information or activity within a private, public, or government organization deemed illegal, illicit, unsafe, or waste, fraud, or abuse of taxpayer funds. Those who become whistleblowers can choose to bring information or allegations to the surface either internally or externally. Over 83% of whistleblowers report internally to a supervisor, human resources, compliance, or a neutral third party within the company, with the thought that the company will address and correct the issues. Externally, a whistleblower can bring allegations to light by contacting a third party outside of the organization, such as the media, government, or law enforcement.
Okay, again, thank you, Mr. Suhaimi. It's a pleasure for myself to be again invited to join this session. Bismillahirrahmanirrahim. Alhamdulillah bi'alamin. Wassalatu wassalamu ala ashrafil anbiya'i wal mursalin. Sayyidina Muhammadin alihi wasahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all Mr. dear participants and also my friends also joining the session, Mr. Suhaimi. So malu sikit lah kan, some of our friends here, so never mind. It's just kind of refreshment perhaps for some of my friends here. So for today, we thought because we have quite tight for today's schedule, because today is Friday and 1:00 in the afternoon, so it's very rush. So perhaps I was going to touch somehow about the law itself and some practical aspect. Whether a person will consider as a whistleblower when they themselves or he or herself comes to MSCC to provide informations, right? First of all, before I go further, please allow me to share my presentations, okay? All right. Mr. Suhaimi, do everybody could see my slides being presented before you?
Yes, it's very clear. Thank you so much.
Okay, thank you, Mr. Suhaimi. I hope the dear participants, you are also able to see my presentations. My presentations is not that too lengthy, because I'm going to give the opportunity for my learned friends, that is Dr. KM Lui, to have more, which is much more experience, and he himself is a expert, subject matter expert regarding to anti-corruptions, especially when we talk about the ISO 37001 and 37002. All right. So before we go further, I believe my dear participants, perhaps I will know. I think most of you guys, you guys do have your own understanding, who is a whistleblower based on your readings, perhaps, based on the movies watched previously. So that develops your understanding who is a whistleblower. But nevertheless, when we talk about a whistleblower between the law that is applied in Malaysia, so we have our own act that governs and provides some protections to the whistleblower itself. So a big questions that arise: are you a whistleblower? Because some of them did come previously or went to MSCC's office, they said, or perhaps they said they are a whistleblower. So do they really a whistleblower according to the law itself, right? So before we start, something that is we need to know who is a whistleblower and in which circumstances that would make he himself as a whistleblower, and what matters that he should share the matters to whom he should share according to the law itself, all right? And how to provide information so that that information somehow helps investigations perhaps, or how would the informations to be channeled in order for the whistleblower himself or herself to get the protections. Right, and later on, I will somehow share to what extent the whistleblower will get protections and in what circumstances, some examples that it will somehow revoke the protections that was somehow provided by the Whistleblower Protection Act 2010. All right. So who is a whistleblower? All right. I will not provide, or I will not somehow quote the definitions in the act itself, right? But I just try to make something that is more easier for you guys to understand. All right. For who is a whistleblower? He's a person perhaps making the disclosure of improper conduct, right, to the enforcement agency, whether verbally or in writing. So the wordings that were I emphasize here, the disclosure of the improper conduct is to be done or to be channeled to the enforcement agency itself. And there are reasons behind it. It's not just the lawmakers not simply put in there because there are some reasons behind it. All right. So it can be in writing or it can be verbally. All right. So there are enforcement agency definitions between the Whistleblowing Protections Act. So when we talk about the enforcement agencies, it says that any ministry, all right, department, agency, okay, or anybody at the federal level or state level or local government which have powers of investigations and enforcement, such as, for example, if you see the logo here, perhaps it will tell you where are they belongs. They are the customs, they are the immigrations departments, any local authorities which they have the investigations and enforcement powers, any existing law. All right. So MACC is I can simply say that MACC is the enforcement agency that is between the definitions of the law according to Whistleblower Protection Act 2010. All right. It's a bit lagging between my slides. All right. All right. So now let us know what is improper conduct. Improper conduct means any conduct which, if proven, is a disciplinary offense or a criminal. So improper conduct can be something that is just an administrative offense, or perhaps it's just regarding to some breach of the code of ethics, for example, right, or some non-compliance with the work process, for example, right. But it can be also to includes improper conduct also includes criminal offense. So there are two there that the law provides, the definitions of the improper conduct. So how would a whistleblower to come forward, all right, to channel the informations that suppose he want to share to somehow, and usually the public at large, they will say that how would I lodge a report? Right. So technically, providing channeling informations and lodging a official complaints, there are some thin line differences or is a little distinction with regards on the providing information, sharing information, and officially lodge a complaints. All right. So the whistleblower, okay, later on I will explain why whistleblowers is just confining themselves according to the law, providing or channeling information to any enforcement agency. So the whistleblower, okay, this is how it should go, all right? The whistleblower may come at the enforcement agency as defined by the law in the sections 2 to be definite, all right? And meet the officer or in any places which both parties agree. So let's say, for example, Mr. A contacted me because he perhaps have my contact number. So he says that, right?
I'm mute.
So the whistleblower will have perhaps he can meet any of the enforcement agency, perhaps he knew at the first instance, right? So let's say Dr. Cam Loy knew myself, all right? So that doctor may contact me, Mr. Lokman, you free at 8:50 p.m. this night or at night? So okay, it's okay. So I have something to tell you. It's just something that I discover, for example. Then, all right. So we will meet at that dedicated, or we agreed to a place where both parties will meet later on. So it does not meaning to say it's just not confined between the official or the office of the enforcement agency itself, which both parties agreed. And the whistleblower later on, or perhaps in other words, the whistleblower can also send the information, all right, by a letter, provides that he or she provide he or she may reveal his identity. Sorry about the spelling here, and the details, the name, contact number, address, etc. And normally, each respective enforcement agency will have their own guidelines to be followed by a whistleblower. So this includes MACC. Yeah, it is the Legal Affairs Department did perhaps provides the guidelines as for the enforcement agency to follow and to provide their own guidelines, so that the whistleblower have some guidelines whether themselves can be regarded as a whistleblower or otherwise. But in other words, right, let's say a person somehow, he sent any informations and he want to by anonymous, for example, all right, for example, Makcik Bawang, for example, Makcik Bawang at yahoo.com, for example, all right. So Makcik Bawang is something that is unknown, right? But the informations that was provided, is something that is genuine, and the informations able for the investigations department to conduct the, what we call, the ingredients is there, so everything is there, so we can investigate the informations that was provided. All right, the information is okay, nothing wrong about that. But if let's say Makcik Bawang, was detected by somebody, let's say the repercussions that was the repercussions comes from the person he alleged. So in that sense, this Makcik Bawang, let's say he's supposed to be, let's say Miss A, for example. Miss A cannot seek protections as a whistleblower. That's the law. Right. All right. Based from the slides just now, it is vitally important to understand. Right. A whistleblower will get protections. Right. Will get the protections if, let's say, he or she comes forward to channel the information to any enforcement agency. Let's say he or she discover any wrongful doings, and it falls under MACC's jurisdiction. So my advice is that if you discover any wrongful or we call improper conduct, let's say it's a kind of bribery. So my advice is that is just go to any MACC office that is nearby in your localities. For example, you are in Kedah, so you have your choice. Either if your office in Langkawi, or you are between in Langkawi, so just go to MACC Langkawi. We do have our office there. And let's say you are in Alostar. Our state office is Alostar, and we do have an office in Sungai Petani too. So you can have a search in our websites to locate our official, or what say, our state office all over in Malaysia, because it is advisable for you guys to go and meet the MACC officers, so that we will explain your positions and your status, whether yourself will get the protections or otherwise, right? So if let's say you guys, we consider, and after some perusal by our top management, there are some criteria that a whistleblower have to fulfill before MACC will regard himself as a whistleblower, right? So if you are now a whistleblower, the MACC now regarded and protected you as a whistleblower. So you will get the protections, right? The confidentiality of the information itself, right? Firstly, the confidentiality of the information. And secondly, it is about the confidentiality of the identity, all right? So like Siti Nurhaliza says, biarlah rahsia, biarlah rahsia. So it remains secret, but the secret will reveal unless yourself or the informer or the whistleblower, let's say, he go he led himself by sharing the informations that was shared previously to MACC by you say wait, okay, I will tell the world, I will somehow please follow my channel, for example. I will share something that is very scandalous. I will share something that is it's a time bomb regarding to perhaps scandals, or let's say wrongdoings between the department or that respective organizations. Right? If let's say the whistleblower, yeah, he did that, then the protections is revoked, right? So that's the confidentiality about the information and the identity. And also the whistleblower will enjoy immunities from any civil or criminal actions. And also, let's say there are repercussions of disclosing the informations and he received some threat, or let's say in the law says that harmful actions from the person who somehow he alleged have commit the improper conduct. So he will get the protections, right? What are the harmful actions? That are harmful actions causing injury, loss or damage, intimidations, disruptions to the job or livelihood of any person. If let's say you received the harmful actions, so now you have to come again to MACC, and so that MACC will investigate to what extent the harmful action now causing you the so-called injury, loss or damage or intimidations, right? So revocations, yeah, if we found that, at the first instance, yeah, after a few Q&A, I will say interrogations, not after a Q&A, yeah, because the whistleblower at the first place will come to MSCC's office, all right? And we will do some screenings, for example, yeah, we will do some screenings as a little bit of DD, due diligence, as to ascertain whether that person is a true whistleblower or somebody like always Rambi says that he has something hidden agenda, right? So if we satisfy after the interviews, right, we specify that he is a whistleblower and we did investigate the informations, right? But somehow in the course of investigations being conducted, right, and we found that he is actually the accomplice of the said alleged improper conduct that was committed by that the suspect, for example. Then he is an accomplice. So if we found that, then the revocations will come, right? So he will not get the protection. And if let's say we found that, or we discover the whistleblower made false statements while providing the information, yeah, somehow in my experience, there are some whistleblowers come forward because they know that his BFF, his BFF, best friend forever, was arrested and was caught by MACC as to make himself not being implicated in that situations, meaning to say his friend was caught. He want to say, I'm not between the league, I'm not the person somehow related to the person that was earlier being arrested. So he come forward providing the information. Him who commit individually, and not meaning to say trying to avoid the implications from himself to somehow being arrested also by MACC. Yeah. So all the revocations can now be apply if the whistleblower committed an offense under the act, right? All I'm just sharing today is something that is very basic according to the law, because I think these basic things is vitally important so that you know how a whistleblower will get the protections at the first place, and situations whereby it can be revoked at any time if the whistleblower committed what I've just shared just now. All right, this is our SOP, okay? This is our SOP. So what happened if a whistleblower come forward to our office, right? So let's say WB, right? WB, whistleblower. So somehow, whistleblower can also become, usually a whistleblower can also comes from a YB, all right? So let's say Mr. what you call Mr. Zack lah, Mr. Zack. So Mr. Zack discover improper conduct. Yeah, in his knowledge, he discovered any improper conduct. Right. So he decided to refer that matter to MACC office. So first of instance, he will comes to any MACC's office available nationwide, including Sabah and Sarawak, and he was greeted. And of course, we will have our duty officers stand by 24 hours. Yeah, we are just the same like police officers. Yeah, we do have duty officers being on duty 24 hours. So the whistleblower now meet the MACC's officer. So the MACC officer will ascertain and somehow will have some Q&A with the whistleblower. So all right. Oh, I think that I did not able to do the right. All right. So when at the first instance, yeah, when the whistleblower disclose his or her identity, all right. Later on, all right, we will explain whether he himself willing to cooperate, and we will ask him to follow the guidelines, all right, the do and don'ts, especially to whether he agreed to follow the guidelines and the rules, so that if he agreed to follow the rules and the guidelines as a whistleblower, then we will ask him to fill a form and we will register the informations and himself. Right. And let's say, I'm sorry about, I'm overlook about the interpretations. All right. Sorry for expatriates or non-Malaysian nationals here. So if let's say he choose not to disclose his identity, all right, let's say so we will not regard him as a whistleblower, and he himself will not be protected under the Whistleblower Act itself. But the information we do accept, and our officer will fill a form, and later on the form will be accepted in another this is our internal process, and the form will be registered and so-called the information itself. And then the form processes again and will be channeled accordingly. And it will now comes to a committees. Yeah, the committees that will decided on the information will decide what are the actions to be taken. For example, whether an investigations to be conducted, or and also the whistleblowers will get the protection. And then let's say the committees decided to take or let us investigate the improper conduct. All right, then the investigations will started and being conducted, and the next step is that after the investigations has been completed, then we will forward the investigation papers to the Attorney General's Chamber's office, so that to wait the final decisions with regards to the outcome of the investigations, whether the prosecutions will say that whether the improper conduct falls between any criminal offence that is applicable in Malaysia, or the improper conduct somehow is just of disciplinary actions to be taken internally, or at the end it's just an improper conduct baseless, so no further actions to be taken. But let's say the informations that was given, something that is frivolous, with sexual, for example, and the committees decided not to perhaps investigate the information, right? Or then it will forward it to MACC State Director's Office or any divisions for any action. For example, let's say for our profiling, for example, yeah, it will not investigate, but there are some actions to be taken, such as we keep profiling, yeah. Later on, we just KIV, yeah, you just KIV, because somehow there are some informers that will provide and will implicate the same suspect in the different session or different submissions of information. So it will make us, somehow. I think the whistleblowers somehow try to tell us something, and later on it depends to the committee again, for example, to decide whether the informations that was given in series, whether we have to initiate investigations or otherwise. Right? So there's a little bit about our procedure in MACC, whether that person as a whistleblower will get the protection or otherwise. All right, lagging in my office or the internet, the bandwidth is a bit lagging. Right, I'm trying to next, just didn't able to move to the next slides. Right. Okay, this is something that is vitally important. Yeah. This is whereby who is a whistleblower and who is a witness. Yeah. So first of all, I would like to explain to you guys or some explanations, all right, so that you were able to identify if, let's say, you want to come forward to MACC, or when you come forward to lodge a report, for example, whether yourself is a whistleblower or a witness. Yeah. So first of all, whistleblower usually will provide information until enforcement agency able to conduct investigations based on the disclosure of the improper conduct, right? But a witness, he is a person being identified due to his or her involvement in the improper conduct, or somehow he has some knowledge within his capacity of holding a position within organization. So a whistleblower easily, or perhaps we can easily say that he himself being protected as to his identity and the information that he provided, he will not call as a witness, right? Being a whistleblower, so he will not call as a witness. But in certain circumstances, yeah, whereby based on the investigations, yeah, because at the first glance, or at the first place, the whistleblower may not disclose everything to MACC. But in our investigations, we found that, yeah, he says that he's not involved, but based on the investigations and the findings of the investigation itself, we discover, oh, somehow get involved, all right? Never mind. So later on, let's say the improper conduct, yeah, and the decisions was made by the Attorney General Chamber's office to prosecute the so-called suspect. So in meantime, during the prosecution's case, meantime in the court case and the criminal proceedings, yeah, the prosecution feels that without the whistleblower testimony, all right, without the oral evidence from the whistleblower, the prosecution feels that our case will not go. Easily we say we're not able to get our case beyond prima facie, meaning to say the suspect at the end will get an acquittal. So we will ask the whistleblower whether yourself want to, meaning to say he will consented that now he will become a witness. So he will not get protected under the Whistleblowers Act. But nevertheless, again, the protection is there, but he will be protected as a witness. But at the end, if let's say he or she not consented with the applications, he can reject the application. So at the end, we will tell that, okay, since you are a little bit reluctant to come forward to be a part of the prosecution witness, so we will expect that the case somehow will less weighted in the evidence will be less. Sometimes it's not, the weightage of the evidence will be a bit lesser. So there's chance that the suspect will get an acquittal. So that's it. So the whistleblowers remain to be the identity remain confidential. So that's it. We can't compel him to become a prosecution witness. But a witness may or shall be called as prosecution's witness at the first place. All right. So he himself will be called, and a subpoena. Subpoena, easy to say, a letter that is signed by the court asking you to come to the court to give your testimony. All right. And again, the protections as a whistleblower, it is provided under the Whistleblowers Protection Act, and a witness may be applied to be protected under the Witness Protection Act 2009. All right. So do not worry. If you are not got protections under the Whistleblower Protection Act, then you again will be protected under the Witness Protection Act 2009. But to be get protected as a witness, a little bit something that is my explanations will become something deviations about what we're talking today. But to be protected as a witness, you have to declare your liability. We didn't want that you get protected under the Witness Protection Program because you are a loan defaulters, you know. So we're not protecting person who are the loan defaulters. So you have to declare your interest, you have to declare your liability so that we know that you are somehow nothing hidden agenda to get the protections under the Act. So a witness, somehow if you are in Sabah, you are in Semenanjung, you are a witness in Peninsula of Malaysia, so you will be placed, or perhaps let's say you are now living in USJ Semanjaya. So there are some the threat comes or people to throw Molotov cocktails to your house. So we reallocate the place of stay for yourself and also your family. So it can be later on your place of stay depends, but please do not update your social media status where you're now belong. As also your kids and daughter, do not update your social media account while you are being protected in the witness protection program. If not, you will somehow face the repercussions as you watch in Kampung People telefilm. Yeah, that was shot in TV3 about a year ago, right? Okay, a little bit about case study before I wrap up for today. This is a case involved the appellant, Puan or Miss Rokia Muhammad, no? He is somebody, she is somehow holding a positions, in the company's commissions of Malaysia, right? This is a case involving herself, contesting about disciplinary proceeding for misconduct of causing the company's commissions of Malaysia into disrepute and brought discredit to the commissions itself. All right, in this case, the disclosure that was made to others had disqualified the appellant as a whistleblower. Okay, the appellant was previously, again, I have just explained just now, was charged in the disciplinary proceedings for a misconduct. She alleged that at the matter of time, all right, the deputy CEO is not fit to be the next CEO due some integrity issues. So the court in the case, it refers that a whistleblower is defined to mean any person who makes a disclosure of improper conduct to an enforcement agency under Section 6. And then later on, the court explained what are the improper conduct, for example, and then for example, the court later on explains in order to get protections under the Whistleblower Protection Act. Yeah, this is a little bit of mistake there. The the Whistleblower Protection Act, the letter B is missing there. Yeah. It's supposed to be WBPA. I'm sorry about it. All right. The person disclosing the improper conduct must make the disclosure only to any these enforcement agencies, not to others. And the present case, Miss Rokia somehow he disclosed the alleged improper conduct to other of the company's commissions member and also to MACC, of course. And also he named and he also disclosed of the alleged wrongdoings to the Prime Minister, the Deputy Prime Minister, the Minister of Domestic Trade, Cooperative and Consumerism, and also to the Chief Secretary to the government. All right. So this makes herself disqualified to become or between the definitions of the Whistleblower Protection Act 2010. This is somehow a case that was clearly, it's something lesson to be learned. Whatever the internal processes that you have, the court simply emphasized that a whistleblower can be protected, may be protected if he or herself go to channel the improper conduct for the disclosure to the enforcement agencies. And if regards to corruption, do come to MACC. So how would come to MACC? Just simply, I think everybody have a smartphone. Just type either you have the Waze applications or Google Maps. Just search on there, type MACC office, and then that's it. It will guide you, and at the end, you will reach in MACC office. And you can have the access, or you can, let's say you want to give a call, then these numbers will help. And again, you can send an email, provided you have to provide your identity, and also via our portals. And perhaps some of you guys may ask me, if I'm sending an email, do myself, my details will be protected. For your information, in MACC, only few officers have the access to the informations in the system, and they have their own schedule. If let's say the system managed to trace he's not duty on that day, so it will give some alarm that a potential breach about the informations, and the protections of the information is a safeguard according to our internal controls. And also you can somehow send a letter and without a stamp and send it to any MACC. It will come to any MACC office nearby. All right. And again, if you have something, you have any queries, you can again contact me at any time. All right. Just come forward. And guys, this is the easiest way for you guys to channel your informations. We do have somehow our own Mac mobile, and you can easily, either you have an Android phone, do access in the Google Play, and if you hardcore iPhone users like myself, then you have to access in the App Store. All right, it's just a fingertips of yours. Just use your fingers, For Malays, you just said you do a little bit tasbih lah on your handphone, then fill in the blank. Yeah, you just fill in the blank because we don't want you to fill blank. All right, just fill in the blank and just send it, and we will entertain and we will act on the information given. And with that, thank you guys, ladies and gentlemen. This is my phone number. It's not a scam. It's true, my phone number. Mr. Dr. Kamloy can confirm that's my phone number. All right, and that's my email, guys. So for more details and informations regarding whistleblowers, you may visit to Legal Affairs Divisions of the Prime Minister's Department for more for your own reading, and some perhaps you could see the guidelines. They will help you to build your internal controls in handling whistleblower channel. With that, thank you very much. And now I think Mr. Kamloy is so excited to share about his sharing. Okay, I think I just can pass to you lah, Mr. Dr. Kamloy.
One moment, please. Thank you so much, Tuan Haji. Alhamdulillah. Thank you, Haji. I can confirm, can verify the phone numbers, right? I often call Tuan Haji Lokman. He's at his kebun doing his gardening. He's very, workout. Yeah. Some of the key point that I can take from what Mr. Lokman said just now. You witness any dangerous activity, wrongdoings, illegal, and you need to become a whistleblower, but correctly. Do not TikTok, do not WhatsApp, do not spread around because you may lose the case. Another thing actually on the social media, if you are under witness protection program, please do not update your status because they will know where you're about. Yeah. Thank you so much, Tuan Haji.
Corporate compliance. Compliance as an action in a business means abiding by government laws and legislation, health and safety standards that have been put in place to protect a company's internal and external assets. It safeguards the company from a myriad of issues ranging from fraud to bribery. It is also a term used when dealing with data and security requirements. Meanwhile, compliance as a standard means a business with a strategic set of rules and policies to help maintain security and stability. However, it is not enough that businesses simply adhere to laws and policies. They must understand whether following these rules will address the actual needs of the internal and external components of the company. Why does compliance matter? One of the primary purposes of compliance is to identify and avoid possible red flags in business. The red flags can range anywhere from money laundering, fraud, bribery, or misconduct. Failure to implement compliance procedures could result in serious legal consequences, which would equate to costly fines or penalties in the future.
I'll pass the floor now to Dr. K.M. Lui, our expert in whistleblowing management system. Dr. K.M. Lui, the floor is yours, sir. Go ahead.
Thank you, Tuan Slaimi. Good morning, ladies and gentlemen. Thank you, my brother friend, Tuan Haji Lokman. It's great to be on the same webinar with you today again. Yeah, we have been together for quite some time presenting the same similar topics related to anti-bribery and corruption. Today, ladies and gentlemen, what I'm going to briefly share with you is about building a better whistleblowing mechanism by adopting what we call a ISO 37001, or 37002, which is a whistleblowing management system. This is briefly what has been introduced. There's some contact. My contact, if you need to reach me, you can always reach me, but I'd like to also give you a quick sharing about what is the association I'm involved today. This is the association of the anti-bribery management system. We call it the ABMS MY Malaysia. It's a registered society, and we have a what we call recruiting members now. So if you're interested, please do not hesitate to contact me. and join us as a member of this Association of ABMS Practitioners Malaysia. Now, at the beginning of this 21st century, the Time magazine named 3 beautiful ladies as the persons of the year. Yeah, and you know that these are the 3 whistleblowers. First, Cynthia Cooper from the WorldCom, Colleen Crowley, FBI officer, yeah, who whistleblow about a agent which they failed to identify and investigate one of the 20 alleged hijacker related to the September 11 Twin Tower bombing. And the third whistleblower is Sharon Watkins. She is actually with the Enron, and this is considered the biggest scandal in the year of beginning of the 21st century. Enron, this is where what happened is that at that time, Enron controls about 25% of the electricity and natural gas, trading about 800 billion US dollars. Their share price was about $90 and then went down to $1. Yeah, after this Enron has been accused of what we call bankruptcy or scandal. Yeah, and the Enron not only brought down their own share, but they brought down one of the big 5. And after this, there is a law called the SOC law. Sarbanes-Oxley Act came into picture in the year 2000, yeah, which required that more stringent control on financial and more stringent check of declarations related to finance reporting. You see that even Enron has a code of ethics, yeah, way back in the year July 2000, and that is where the peak of their share. And of course, almost within 5 months later, after this scandal, the share of this Enron went under $1. What happens is that after this Enron case, the new law, SOC law, came into picture, yeah, which now makes the accounting firm responsible for overseeing and regulating the auditing process, make sure that the internal controls are there, and ensure financial disclosures. That is what happens after this Enron case. Sarbanes-Oxley law is been put in place. And 8 years later, in the year 2010, UK came out with the Bribery Act to address Section 7 of the corporate liability. And of course, if you realize for the last 15 years or so, a lot of anti-corruption law has been revised and updated to address this corporate liability law. For example, the Brazil Crane Company Act, Argentina Corporate Liability Law, Peru Liability of Legal Entity, and this is a new wave of legislation. So much so, 8 years after the 2010 UK Bribery Act, Malaysia, MACC, we came up with our own Section 17, capital A, similar to the Section 7 of the UK Bribery Act, addressing the corporate liability. This Section 17, capital A, was passed in April 2018. It was only gazetted in May 2020 and came in force on July the 1st, 2020, for this particular Section 17 capital A, which is the corporate liability, and came in force. Yeah, and as you know, Section 17 capital A is the offence by the commercial organisation. Subsection 1 says that a commercial organisation has committed an offence, yeah, if someone has corruptly promised to give or promise of offer any person any gratification when they obtain any business or attain business for their advantage. And you know that subsection 2 defines the fine, which is about 10 times the amount, sum, and the value of the gratification, or 1 million ringgit, which is ever higher, or to the imprisonment of not exceeding 20 years both. And this Section 17A, capital A, you realize that subclause 4, subsection 4, says that if a commercial organization has been charged for this offense, there is a defense for this organization. And the organization has to prove that they have put in place what they call an adequate, yeah? And this adequate procedure has been issued by the Minister in the Prime Minister Department, and is what today we call the Ministerial Guidelines on Adequate. And copies of this adequate procedure can be obtained, yeah, download from the GIACC website, and even what we call handbook, best practices handbook, has also been developed to help the industry to address this corporate liability and the adequate. Transparency International Malaysia is going to develop a guidebook, a similar adequacy procedures guide as well, and they will probably publish in December during the International Anti-Corruption Day. With this, you realize that what happened, our adequate procedure spelled out under this trust, acronym trust with the 5 principles. You must remember what happens that way back in the UK Bribery Act 2010, they do have this adequate procedure. Their Section 7 addressing the corporate liability also says that you have to have 6 principles adequate procedure in place, and that where we adopt this principle as well. So in this principle number 1, top level commitment, is spelling out that top level commitment have to encourage the use of reporting, whistleblowing channel, in relation to any suspected or real corruption incident, which UK Bribery Act, their adequate procedure principle 1 spell it out the same under the proportionate procedure. Now, adequate procedure is not only unique in Malaysia. Other countries who have corporate liability law as well, for example, Thailand, they also adopt their adequate procedure, and they call themselves fundamental principle. And under this number 7 fundamental principle, it also talks about communication channel to encourage report. And these are what they're trying to establish here, whistleblowing mechanism that is used to address corporate liability. So principle 3 of our adequate procedure under the acronym TRUST is spelling out that you have to have this reporting channel. And this reporting channels that commercial organization need to develop a confidential, trusted reporting channel, a whistleblowing channel, right? And at the very least, for smaller organization, you can use a simple whistleblowing channel, a dedicated email address, which encourage the people to report, in good faith of any suspected or attempt or real actual incident or wrong, right? So they have different channel of whistleblowing, and email from a survey conducted by the EEQS group. It's indicate that survey using email is considered one of a very popular whistleblowing channel. Germany, France, UK, and there are others whistleblowing channel. A lot of other organizations are using phone call as well. But sometimes it can be challenging to us, because in 2 occasions I observed a company have this whistleblowing channel by telephone. And prior to the auditing, I called them, called their hotline 5 times. But out of 5 times, only 1 time somebody answered that call. Similarly, at one situation in another organization, during the audit itself, we make a call to their hotline in front of the managing director. And the call itself went on ringing for more than 5 minutes. So it's equal frustrating if there is a proper channel, but it was not tended to. Wrong. Besides the adequate procedure, I want to stretch here also our Malaysian Code of Corporate Governance has been talking about whistleblowing policies and procedure way back in 2012. It was not only until 2017 it becomes a requirement for the public listed company that you have to have now a whistleblowing policies and procedure. And with the updated version of the 2021 corporate governance, it re-emphasized the importance of this whistleblowing policies. However, and even now that with the latest listing, if you going for public listing, it's a requirement now that you have to fulfill or put in place this policy on whistleblowing. All right. Okay. Now, what I'm trying to say here is that guidance or the corporate code of conduct is that they are actually asking for a whistleblowing mechanism, which is what we call internal whistleblowing. It is basically whistleblowing at place, raising concern or pick up or spill the bean. So there are 2 types of whistleblowing. One is internal whistleblowing, which is what is important to us as is required under the BUSA and also the adequate procedure. And the other whistleblowing is called the external whistleblowing, as is when employee or anyone informs about the wrongdoing to someone who is not part of the organization but to the enforcement agency and other authorities. So I like to emphasize more on the internal or the whistleblowing rather than the external whistleblowing, but there are also some concern. And because of the external whistleblowing, and that is why we have our whistleblower protection. And this act is basically to provide protection to whistleblower, if they if they face any issue, related to detrimental control or treatment after they have made the disclosure to the enforcement agents. And that is why under this protection act is that you only get protection, and get immunity from civil and criminal action, and protection from detrimental action when you whistleblow to the enforcement agency. And that is what has been explained by our Tuan Haji Lokman. Okay, so there's one example of 49th Whistleblowing Protection Act. And today, the EU Whistleblowing Protection Directive has become very important for the EU, that most of these country members has to establish this directive in their own country by December 2021. Okay, and that's a survey by this International Bar Association in the year 2021, this year. They conduct this 49 countries Whistleblowing Protection Act, and they established 20 best practices. And out of these 20 best practices, for example, in the reliability protection, out of 49 countries, 30 countries have these best practices, which include our Malaysia Whistleblowing Protection Act. Of course, they are EU and also USA. And out of these 20 best practices, the survey came out that Malaysia, our Whistleblowing Protection Act, is only 7 out of the 20 best practices, right? Moreover, out of all the 49 countries, EU, USA, and Australia, these three entity or jurisdiction score only 16 out of the 20 best. So what I'm trying to say is that our Whistleblowing Protection Act needs to be enhanced to address the best practices, what is spelled out in the outside world. All right, it's only 7 out of 20, and that is why under the National Anti-Corruption Plan, there is a provision, a proposal that to improve the provision of this Whistleblowing Protection Act. Okay. And which I believe and I strongly urge that the GIACC and others relevant parts to look into the International Bar Association Bar, which I conduct this survey, and look into this survey, what would be the best practices that we can incorporate to improve our Whistleblowing Protection Act. For example, under EU, you can whistleblow to any channel and whatever means you choose. But in our Whistleblowing Protection Act, you get only protection if you whistleblow to our agents, enforcement agents. So that's a different school. And back to here, what I'm trying to stress again is this internal whistleblowing mechanism. So the ISO decided to come out with this management system, and it's called ISO 37002, which was just published in July 2021. So this standard is basically helping the organization to establish and implement an effective whistleblowing mechanism. All right, it is allowing this internal reporting, which about reporting a wrongdoing, and it is carried out the most efficient way. So we have a series of meetings since the year 2018, and we have received comments like 800, 370, and also 500 comments during each session. And finally, we discussed and debated, and we published the standard in July 2021. And this standard now, it becomes such an important guidance book for those companies in EU because of their own EU whistleblowing protection directive. Every country need to implement this, and every organization in the EU have to prepare themselves for this as well. And it is so much so that this whistleblowing management system has become a complementary and supplementary to the EU directive. So this is how the structures look like. Similarly to any management system, they have the 10 clauses, but the key area is always the core of this management system is still the operation number 8. And we talk about receiving report, assessing the report, addressing the report, and also concluding the whistleblowing case. So if you have a management system, whether it's 9001, 14,000, or even the 37,001 management system, this whistleblowing management system comes in handy, and to help you to develop a whistleblowing mechanism. Okay. In text, you realize that this is how they spell it out. The blue text is where the relevant clauses related to whistleblowing. What I like to highlight are some additional area when you implement this management system. For example, here, training for the leaders and other specific roles. So we may have training to share amongst the stakeholders about what is the whistleblowing mechanism is about. But it's also important for the leaders and also those who are involved to receive whistleblowing report. What do they do? How they're going to do it? How they're going to address it? This is also very important. All right, this is some area of this important area that you need to cover under the whistleblowing mechanism. And I say the core of this standard is actually under the operation clause 8. Yeah, receiving, assessing, addressing, and then concluding the whistleblowing case. Okay, this is the outline of this. Now, this is also a simple flow chart, which work on is what we call the operational step: receiving, assessing, addressing, and concluding. Yeah. So this is how the mechanism works. But I'm not going to go into detail. But I want to spend more time talking on the other perspective of it. Okay. Now, the general definition of whistleblower is something that someone who deal or review wrongdoing, or someone disclose information about misconduct, or someone who speaks up trying to expose corruption or dangers to the public or environment. Okay, this is some general definition. Whereas what that Tuan Haji Lokman had mentioned is that our Whistleblowing Protection Act, the definition of whistleblower is actually related to disclosure of improper conduct to the enforcement agency. So that is their own definition within the boundary of the Act 711. But this is our general definition of whistleblowing as far as the internal whistleblowing is concerned. So our internal whistleblowing mechanism talks about whistleblower, a person who reports suspect of actual wrongdoing, and they have a reason to believe that this information is true at the time of reporting. In other words, they are reporting in a good faith at that moment in time. All right. So this whistleblower can be any person or personnel within the organization, external party, subcontractors, your business associate. It could be even a union representative or someone who was formerly in the ex-staff. So we are trying to use this word called the wrongdoing. Wrongdoing is an action or omission that can cause harm, right? Today, or rather that some of this whistleblowing policy you see, they are still using this word malpractice. And today we don't use this word malpractice anymore in the whistleblowing policy or procedures. We're trying to establish this word wrongdoing. And wrongdoing has to spread, because if you do malpractice, it's a negligent, So it may not be a true negligence, but it could be a wrongdoing. So in our context of the ISO 37002, we define a wrongdoing instead of a malpractice. These are some of these areas which include the wrongdoing, the definition of wrongdoing, right? Of this whistleblowing mechanism, it is so important to know that you have to know that the reporting of a suspect of actual wrongdoing, it can be a three mode. One is called the open whistleblowing, which the whistleblower disclose information without withholding their identity, understand? Or requiring the identity be kept. Second one is confidential whistleblowing, which the identity or any information of this is not disclosed without the consent. Okay, and of course the third one is the anonymous whistleblower. If you are subscribing to ISO 37001 ABMS system, this requirement of this 37001 spell out that you have to allow anonymous report, and this is very important. There are some whistleblowing statement which I picked it up. For example, Bank A, whistleblowers are encouraged to provide their identity or contact details to facilitate the bank to clarify or obtain further information for the purpose of further investigation into the improper conduct. Plantation says that whistleblower may choose to make an anonymous reporting, but the Integrity Department reserves its right to investigate or not to investigate. Number 3, state-owned enterprise, the GLC. Any anonymous disclosure will not be entertained. And Bank B says that all whistleblowing reports will be assessed regardless of whether the whistleblower's identity is disclosed or anonymous. So this is something we need to reach out. So whether your system allows anonymous report. But what is good in this management system, the whistleblowing management system, is that we should receive all report. It means wrongdoing report we receive from all channels. And then whether it is open, whether it's confidential, or whether it's anonymous reporting, we receive all this. Then the step 2 is that assessing. And this is where we do the drainage to identify whether there is enough information. Even it's a surat layang, or in Indonesia they say surat Karen. So we have to assess Some may be very brief, which do not have information or back detail. We'll triage it and say that we will not be able to proceed further because it's a lack of, even if it's anonymous, as Puan Haji Lokman had mentioned, is that they have full details, information, time, date, supporting evidence, of what has taken place, wrongdoing has taken place. That may be necessary for us to conduct the next step, which is addressing. Investigation need to be carried out. If there is some investigation to be carried out, then you have to ensure that you will do a proper investigation, looking into whether this warrant action to be taken. And if you find out that, yes, conclude that conclude that wrongdoing has been conducted or has happened, now you take the decision what to do. And that is the recommendation and decision making of this whistleblowing mechanism. So basically, whistleblowing talks about receiving, assessing, addressing, and then concluding the whistleblowing case. If you conclude that there is such a case, a wrongdoing is found, then you will take appropriate measure to resolve it, to monitor the situation, to administer sanction, or to refer to relevant authority or even external authority, and then monitor or make the. That is where your outcome of your whistleblowing is what you're going to do after that. So the intent of this mechanism is that we allow a whistleblowing mechanism to ensure proper reporting of wrongdoing, support and protect the whistleblower, ensure proper reporting is dealt with properly and timely, and also improve the culture of integrity and governance, and also to reduce the risk of wrongdoing. So that is important for us, that this whistleblowing is built on trust, and this had to have to make it happen. This needs to be addressed. So what is best out of this whistleblowing is that sometimes it allows us to identify and address the wrongdoing at the earliest opportunity, and these are some of the benefits that we thought that it will help us when we implement this management system. All right. Two important areas of this management system is that you have to ensure data protection, and this data protection is very important. And we have to decide during the whistleblowing which are this information considered privileged information or document, because during this investigation a lot of information are considered classified and also very confidential. Similarly, the identity of the whistleblower and the interested party who could be the witnesses need to be ensured, secured. And whenever this confidentiality has been breached, support has to be provided and disciplinary action need to be taken against the violation of this confidentiality. And the whistleblower needs protection. This is very important under our whistleblowing mechanism. So we need to protect the whistleblower from detrimental conduct. Okay? And besides protection, and sometimes they need support. So support is equally important. So when the report of wrongdoing started or been received, support in terms of encouraging, assuring, emotionally, financially, legally need to be enhanced and need to be provided not only to the whistleblower, but also to the other relevant interested party, such as the witnesses, and those who are involved as the colleague as well. Okay, so this detrimental conduct, this is what we say that important, so that they are not being action being taken or involved in retaliation. Okay, whereas our Protection Act has a different focus on detrimental action. What our ISO 3937/2002 have a full description of what are this detrimental conduct is about. Right? We talk about it could be a threat, a proposed or actual, direct, indirect action or omission, which may be result in the harm to the whistleblower and other relevant interested party. For example, the witnesses as well. Okay? So these are some important areas that we need to address to make sure that retaliation, reprisal, or any conduct taken against the whistleblower has been assured or has been contained. So you realize that whistleblowing is not an easy task. Sometimes we are faced with this ethical dilemma. The effect is that sometimes they are reluctant to blow the whistle because they are worried. Yeah, they may fear of reprisal or retaliation. The second ethical dilemma is that a death effect. Some of those people, the compliance unit are reluctant to whistle this whistleblower because they say, I received so many complaints, so many reports. I will escalate this report, but I appreciate your effort, but thanks but no. Another fear of this dilemma is that blind effect. Reluctant to see the need to whistleblow. So why? This is just a normal thing. It's a way of life. Why do we want to whistleblow, make things so difficult? So these are the dilemma sometimes we do face. Why? And to address this is because there could be some barrier to this successful whistleblowing mechanism. There's no trust. There could be a misguided union's solidarity. Believe that the management is not going to help same standard. Fear of alienation from the peer and fear of retaliation. And to address this, similarly, we have to avoid this pitfall. So there should not be any delay investigation. It should not be insincere double standard. Protection need to be there. Okay, support need to be there. Make sure there is a management commitment. Sometimes the policy itself is not clear and there's no follow-up. So to win the confidence of the whistleblower, equally to enhance, to make sure that there's no such ethical dilemma, these are some areas you need to enhance. Communication, confidence, respect their request to remain anonymous, follow up, ensure top management commitment and support. Understand? Exceed, if it's possible, that you have to control, make sure it's firm, but not compromising on their professionalism. Continuous report. Similarly, to ensure that there's a success for the staff employee to report in good faith, there must be a proper policy. Leadership, by example, tone from the top and also conduct from the top. Understand? Have a better protection, strong support, easy access, company-wide awareness training, communication, feedback, and also data protection and confidentiality. It's very important to ensure the successful of this management, right? So with this, ladies and gentlemen, I just want to share with you what we do at the international level of this Technical Committee 309. This Technical Committee 309 Governance of Organization, we have already published the ISO 37000, which is the governance of organization. We have also published the standard 37001 standard and also a guidebook or handbook on this ABMS. We have completed this whistleblowing management system. This is the 37002, just published, and it's very useful now in the European EU country. And of course, we have also published the compliance management system, ISO 37301. Again, it's gaining momentum, especially compliance requirement to even the legal requirement as well. In China, the government in China is coming out with a new directive which required compliance, and some legal entity has to fulfill this compliance requirement. So much so that this standard compliance management system becomes a very useful management system and tool that will be guide and useful in China when they look into this compliance of these organizations. So in the pipeline as well, these are some new standards that we are going to develop. Anti-fraud control 37003, governance maturity model 37004, selection of indicators, guidance for governing body 37005, 37006, indicators of effective organizational governance, 37007, guidelines for efficiency. Lastly, there is one standard, what we call technical specification, 37008, which is called the internal investigation. So this is coming, what I'm trying to say, that this is complementary to our whistleblowing mechanism. So with the whistleblowing, it is just a whistleblowing process. After the output of the whistleblowing, if you need to investigate and carry out, so this technical spec 37008 comes in handy to complement the whistleblowing management system. And this standard is working, and now we target complete within 18 months, 1.5 years to address. So with this, ladies and gentlemen, thank you very much. I finished right on time, 11:30 as target, and I'm now happy to pass this mic floor to the organizer. Thank you.
Thank you so much, Dr. Louis, for sharing your thought and advice you spend your time, explaining one by one in details all the in your slide. Yeah, certainly you are subject matter expert in this area. I'm quite intrigued about your thought on the Whistleblower Protection Act that you said need to be enhanced further. Yes, Doctor? Need to
Yep.
enhance further. Hopefully you can take it to a bigger platform so they can share with the audience. We have a question from Miss Arifah from Kumpulan Buang Persaraan. Yeah, Tuan Haji Lokman, she asked us, does it mean PBT, local authority, is also an enforcement agency, Tuan Haji Lokman?
Okay, basically, if you look at the roles of the PBT or the locals authority, they can be also included, but yet to be any case law decided to define whether the local authorities are between the definitions. Yeah, because most of the cases, if you read at the preamble of the Whistleblowers Protections Act, is something about channeling informations about corruptions. And usually we are the sole agencies that accepted a lot of informations regarding to the improper conduct. But nevertheless, to answer the questions, basically, in my opinion, yeah, if the enforcement agency between the PBT do have the powers between as defined in section 2, they can be what we call, if you trusted them, you can go and channel the informations to them too. And they can offer the protections unless the case go to the court for any disputes or somebody challenge about the powers of the PBT. For example, if let's say MPSJ is defined within section 2 of the whistleblower process.
Yeah.
Can I add to this?
Sure. Why not? Why not? Yeah. Just go ahead, Doctor.
MACC, by its virtue of its existence, they have a better mechanism to receive report. Understand?
Yeah.
And they have this put in place of how a whistleblower can report wrongdoing. Understand? If you were to look into the other enforcement agency website, whether it's JPJ or custom or even police, what you can find in their website is actually not a whistleblowing channel, or rather a complaint section which you can raise a concern or phrase or appreciate the work of that organization and the officer. So if you say PBT, for example, MPSJ, yeah, I'm not too sure whether they have a proper mechanism to receive whistleblowing report. So I like to alert this issue. Some enforcement agency do have a reporting channel, but not whistleblowing reporting channel. And that is my doubt, yeah?
Yep.
That is my concern.
Yeah, I do agree, Dr. Kamla. If you trusted them, then go.
So you have to be cautious. I mean, this is the threat. I have served MPSJ as a counselor for 5 years.
Yes.
Yeah. Under not a political appointee, but under the NGO quota then. Noted, but just
disclaimer.
Thank you.
Okay, thank you, Doctor. Thank you, Doctor, for that.
But I believe we are unsure. Go and see MCC, right? Dr. Haji Lokman, get the advice first. If you're not sure, because sometimes you are skeptical whether am I doing the right thing or not. Why not? As what Dr. Haji Lokman said, MCC have the branches all over Malaysia. You don't have to pay anything. It can be anonymous, drop by and seek their counsel. Why not? Yeah. Another question from Andros Lim from Tay and Partners. I'm going to address this to Dr. Lui, but Dr. Haji Rahman do chip in. Yeah? In a commercial organization, ordinarily any suspected corruption incident will be reported internally for internet investigation like DI, domestic inquiry, prior to being reported to the authorities before reported. Yeah. In the event of company reports such as incident after conclusion of the internal investigation, will the whistleblowing protection still be afforded to both the individual employees and the company? I would like to read one fact from the survey conducted by KPMG. Says that KPMG Forensic in 2020 says that 65% respondents said that they are allowed to go to any third-party channels, but 35% respondents said they are limited, to report only for the identified or the channel that have been determined by the company. My question in sync what been asked just now by Mr. Andros just now, does not this mean that we are limiting or restrict the freedom of reporting, Dr. Louis? Yeah, go ahead.
Thank you. This is a bit tricky because the question comes in is that
Doctor,
what kind of
dilemma?
Yeah, no, I would not want to go into the external whistleblowing, but rather focus more on the internal whistleblowing mechanism. So as I explained, the internal whistleblowing mechanism allows us to initiate this report of wrongdoing. And after investigating that, the committee realized that it is too hot for them to handle, correct or not? And there is element which need to report to the authority, then they have to do so. Because you have to realize, yeah, sometimes, which I don't intend to go into it, is that under the MACC Act, Section 25, there is a statement called failure to report. And any person who knows and fail to report an act of giving or offering bribe or soliciting or obtaining bribe has committed an offense under Section 25, subsection 1, 2, 3, and 4.
Yes.
Yeah, that is a concern. So, but important thing is that we must describe it what is within our boundary under the internal whistleblowing mechanism. So the rest I can pass to my Tuan Haji Rahman.
Tuan Haji Rahman, does this mean, Tuan Haji Rahman, means that even though the company insists that they go internal channel, but if still the whistleblower wanted to go direct to MC, can they do that, sir?
Right. As provided by the law, the requirement of the law, it doesn't limit it how to channel, but nevertheless, it spells out the protections. If you decided to channel to MACC that was named among the enforcement agencies, then the law says that you will get the protections. But if, let's say, that Dr. KM Loy had just elaborated just now, so if between the organization you do have the whistleblower channels, there's nothing wrong with that. But in any event, there are repercussions, intimidations, harmful actions against the whistleblower, then nothing much they can do. Because they will, if let's say the protections was given, then it will become ultra-vires because the law doesn't provide the protections. So again, like the Teko Amla stated that Section 25 is vitally important because if let's say you guys get involved in the transactions, it is duty bound, it's mandatory. Failure to do so is an offense. But let's say you have to differentiate yourself. If yourself is going to be a witness or yourself is a whistleblower. Your whistleblower is somebody that's going to spark investigations to be conducted. And meaning to say, you will call as a witness. Yeah. So it's a little bit dilemma. And that's why I think that the Comloy, even though in MACC, we do ask for something to be done about our act, but I cannot condemn the act because I'm the law enforcement. So if anybody wants to know my opinions, we can have a tarik sessions, which is not recorded here.
But I like to add one more here is that we have to be very careful and realize this. A whistleblowing mechanism or management system is a whistleblowing mechanism. Whereas our Whistleblower Protection Act is a protection act. It's not a whistleblowing process.
Yeah.
Don't confuse. It's what I say. Under the corporate governance and also under the adequate procedure, we are asking for a whistleblowing policy and a procedures which should put in place. And it's not to be confused with the Whistleblowing Protection Act. However, in your whistleblowing mechanism, and you describe that the outcome is that we decided to report to enforcement agency. So what is that process? So whether to seek protection, because the word protection means that you only get protection if you undergoes this, that. Otherwise, no protection to be given to you. Habis cerita. Itu aja.
Thank you. So further than that, we need to talk to the country's lawmaker lah. We cannot do anything. Yeah. Okay, we have the third questions from Mr. Nasro Effendi. Hi, he said public still have perception that their details will be disclosed somehow. So bocor seorang bocor lah, yeah. Their identity is revealed. Beside the act, how else will the whistleblower be protected against the any repercussion? Yeah. Speakers, anybody could like to start?
I can't see your question.
Yeah.
Mana, ya?
Okay, let me add up with regards to MACC's jurisdiction. Okay.
Yes.
The answer would be short. Let's say a whistleblower come forward and do share some informations, and they got protected. And somehow one of the MACC officers, disclose the information, right? So disclosure of the MACC officer is an offense, but the whistleblower, if he's a whistleblower, he again can be protected.
Sure.
He can be protected because it's not on his fault, right? It's not on his fault. The protection will not be revoked because it's not himself. It's the MACC officers who somehow, like Mr. Swami said, he will go make some TikTok, Okay,
Yeah.
Dr.
Then again, Dr. Louis, there's a fraud magazine, research done in the article said that 74% of whistleblower were terminated. 74% were terminated. 6% were suspended.
True.
And 5% were transferred against their wishes.
Yes.
This
it's true. Statistics do show a lot.
So how can we assure that the protection really protects and they really protect them and the witness protection program works? Come on, please share.
Yeah, that is very important, as I mentioned about your ethical dilemma as well. Correct?
Yeah.
Now, that is where the few points which are highlighted to have a successful whistleblowing mechanism. The trust must be there. Mechanism, the process must be there. Equally, you have to put this, workable. So I show you some point in my slide that these are some important areas which most of people oversee. It's just like even what we call kadang-kadang ni harap pega makan padi kan, betul tak? So sometimes the top management itself is a big question. So how are we going to whistleblow when we realize that the top management has some issue? That is why I use the word not only tone from the top, it's actually the conduct from the top, and that is actually very detectable. But one weaknesses in our Whistleblowing Protection Act is that in Malaysia, we do not give reward. And I think some agency has decided to look into the reward system. Indonesia has started to give a reward system. But in USA, the Security and Exchange Commission, they have rewarded at one time maximum of 10 million US dollars.
Wow.
Yeah, that's a lot of money, But of course, they have actually, I just don't have, I have a figure, but it's in another slide, which I can show, I can mention that they have actually giving reward. But the question is that, does reward means anything? But this is only related to third party rewarding. But I did mention also in our internal whistleblowing mechanism, there should be some support. A support could be incentive as well. but it also could be a moral support. That is where comes in handy. That's the big question mark whether we would like to consider this. Thank you.
All right, thank you, thank you. All right, okay, good. Next question from Gamuda Muhammad Khairi. With some recent decision by the court on some corruption cases, what is your opinion that a potential whistleblower could be discouraged from whistleblowing? Because the court, I wouldn't say anything. From the authority point of view, Mr. Dr. Haji Lokman, there's a question there.
I would like to see in there. Oh, with the recent decisions or some corruption
Yeah,
cases.
from Mr. Muhammad Khairi Gamuda. Yeah.
All right. In my opinion, is that this somehow, I would say like this lah. Let me say like this. Some in the corruption cases, investigations, so the evidence is there, witnesses is accessible, but in my experience, being a prosecuting officer about 9 years in service, so many things could happen in the corruptions case, especially the cooperations from the witness, and technical issues regarding proving a corruptions case. So I think, in my opinion, a whistleblower should not be discouraged because it's a part of your fight, right? And we do appreciate because somehow it unearths something that is happened between the organizations, perhaps. If let's say you keep quiet, and it will somehow make themselves feel they are above the law. And it was just something deterrent factor for those guys who somehow, it's not that being released, you didn't have some repercussions earlier. You will get some Q&A by MACC's officers, and this is something that usually the public is not, even I would say that MACC office, we do have 5-star hotels, 20 rooms available every day. So I don't believe any of those guys want to stay in our 5-star hotels rooms that is available. It's not underground, it is still above sea level, but I don't think you would want to be there, even though it's 5-star hotel. But the repercussions is there, but always, in most corruption cases, there are few as accused, because they get acquittal. There are rare cases they will somehow initiate civil proceedings against the complainant, because it is, I would say, it's a rahmat lah. You get acquittal, so thank God for that, and keep quiet after that, But also there are repercussions and civil actions to be taken, but somehow it's not can be easily substituted, because there's cases that during the investigation, because he get an acquittal, so he will put a lot of elements, is that MACC have beaten them, during the custody, and a lot of stories after the criminal proceeding had ended. So a whistleblower should not be discouraged. You should be proud what have you done, because somehow you unearth some wrongdoings happened in the organizations. It's my opinion. It's my opinion.
Doctor?
Not much. I don't want to. I don't have much comment on that. I don't think I like to comment. Just go ahead.
But I think actually, becoming a whistleblower is not a right actually.
Yes.
It's about protecting the company position. Sometimes top management didn't know about this. The middle management is doing all the hanky panky, right? So we are trying to protect everybody for a lesson learned. And something like so to tighten the screw. We go ahead for next question. Thank you, Tanjaman, for that explanation. We have from Mr. Azlan regarding your slide, Tuan Haji Lokman, is mentioned whistleblower must agree that if a call must agree if a call as a witness. But wouldn't that discourage whistleblower to come forward knowing their possible risks? The case in Africa of the murder of Babita Dokara, I'm not sure about this case, last August 23rd, was a wake-up call. Tuan Haji Lokman is quoting your slide.
Yeah. That what I just quoted. It is exactly what the guidelines that was provided by the legal affairs divisions. All right. So basically, because a person is a whistleblower, he get the protections. All right. But let's say, like I just explained just now, and let's say the prosecution team says that whistleblower is supposed to be our witness too. You know, he can be his help is much needed in order for us to secure a conviction, for example. And in that juncture of point, because he himself is a whistleblower, so we have to get the consent. Because if let's say we disclose the informations of the whistleblower, it will against the requirements of the law. So it's not that somehow to discourage him, because some cases, especially involving high profile cases, if let's say the cases is about against the flow, so we have to frankly tell him that if you willing to cooperate, then that's it. We will put you another protection that is to be protected under the Witness Protection Act program, a Witness Protection program. So there are other conditions to be fulfilled. So do not worry, because you just shift your shoes, you just shift your positions from a whistleblower, and of course you're always protected at the first place. And secondly, if you agree to be a prosecution witness, we do protect you as a witness. But the protections under the whistleblower is not to be applicable if you consented to the applications. We can't force him, but we will tell the effect and consequences. Okay, if you come forward, then he will lepas lah, and you have the konderi doa selamat lah, sembelih kambing.
Okay, Doctor, you want to comment?
That's what's that the people after getting an acquittal.
Yeah. You're right. Doctor, yes, Doctor.
This, I think, this is more about weakness. I think Tuan Lokman can answer this better than me. I don't want to get involved in this.
But I'm
My
sure,
comment is that
I'm sure MSCC have talked about this. They know what they are doing, so
exactly.
they know how to protect the witness.
So once you whistleblow, it's a whistleblow. That is why I say among the whistleblow, you will probably call other witness as well to back up your whistleblowing report. So to me, you are the whistleblower. You could be also the witness itself. But sometimes you need other witness to come in handy. That you when you whistleblow something and you have some evidence or some witness to also support that you witness something on that wrongdoing. And that is what I mean by witness.
All right, okay, good. Next question from Mr. Anthony Mudajaya. If Whistleblower Protection Act only apply to report directly to enforcement agencies, will the whistleblower within the organization, example, the integrity team, disqualify him or her from protection, HR, so to say? Dr. Louis?
So basically, you see what happens is that if you have a Roberts whistleblowing mechanism, internal whistleblowing mechanism, you are supposed to look into, remember I told you, protection and support. These are the key elements in our internal whistleblowing mechanism. So if you want to have a good whistleblowing mechanism, these are the two criteria you have to ensure, which is the protection and the support given to the whistleblower. Understand? Yeah. But of course, there won't be what we call a whistleblowing protection scheme like MSCC can offer tukar nama, tukar alamat, and all these things. Tak ada lah. You're still working in the company, right? But what I'm trying to say is that this whistleblowing mechanism should provide a provision where when somebody who whistleblow, their identity are protected. Understand?
Mm-hmm.
Yeah. And also that is where protected from what? Protected from the detrimental conduct that people may take retaliation. People may take some peers pressure, things like that. And this need to be protected, and that is need to spell out very importantly.
Oh.
But it's only that when you need when the case is really big, whistleblowing protection, directed or rather you whistleblow to the external, then this Protection Act comes under what we call this Act 711, which is different context. Yeah, thank you.
Okay, right. Thank you so much. Yeah, we have another question from Azizi Rashida, Miss Azizi Rashida from Perusahaan Air. I think the question have been answered just now. So other question will be, wow, Andros have a follow-up question, sir. Just now he asked a question and the question. Next time you need to pay, Mr. Andros. I understand from the slide that the whistleblowing protection will be revoked once the information is disclosed to a third party. This may include disclosure in a domestic inquiry, in the internal whistleblowing and investigation process. This means that an employee discloses some information within the company, the whistleblowing protection under the WBPA will be revoked. Doctor?
Okay, my comment is very simple. The intention of internal whistleblowing is to receive wrongdoing, and it should be contained within this organization. Understand, right? So when you need external protection, you're supposed to report only the enforcement agency, and you will lose protection if you broadcast to other than this enforcement agency. Just like what Haji Loman mentioned, you informed the PM, you informed the deputy PM, you informed the ministry and everything, the press, and also your neighbor. That is our contact. Betul tak? That means you don't get protection because you have broadcast the sensitive information about this whistleblowing to others. Betul tak? So what I'm trying to say that if you still whistleblow, you bring a contain, means that it's only a selected individual in the organization are investigating this misconduct or wrongdoing. And it is actually warrant to be reported to external enforcement agency. You will have the venue to provide that you will only report now to the enforcement agency and not broadcasting the whole incident. That is the important thing that we have to really stay focused in this context, not to confuse the whistleblowing act plus the whistleblowing mechanism. Thank you, Enos.
Haji Loman?
Yeah, I think doctor has explained a little bit very detailed. We must able to differentiate the protections and also the channels itself. How do you develop? I think the camera says that basically know your enemy. Know your enemy. And if the channel says that, if let's say I'm going to disclose information going to the compliant, for example, I'm going to report about, let's say, the board member. So within the system, perhaps, okay, we got to that board member. If it was agreed in the company as a part of their system, reporting system, then that matter, I'm advising you to report to MACC. That's the best. That's the best.
That's the best. Report to MCC. Yeah.
That's
the body recognized for all this. Yeah, I think that's the best.
One size doesn't fix all also. So it has to be a case-to-case basis.
Yes.
Yeah, understand.
Yeah.
So again, wrongdoing, what type of wrongdoing we are talking about?
Yes.
Yeah, what's the impact, So there is some area we need to establish. Yeah,
Yep.
Thank you.
Thank you, Dr. Kamla, for add up.
Okay, right. Okay, let me. Yeah.
Sexual harassment or online harassment case at the workplace to be a whistleblower. Now, it also depends on the scope of the whistleblowing. Whistleblowing mechanism, as I say, is wrongdoing, and it can cover all aspects of it, understand, including sexual harassment, violation of health and safety issue, and that also should be covered. However, please take note, I think personal grievances should not come under whistleblowing. So grievances should be handled under different category. So you don't whistleblow personal grievances under this whistleblowing platform, understand? But other means that violation of any compliance, yeah, it is also considered these activities to cover, like sexual harassment, health and safety issue, that should cover. Thank you.
Yeah, thank you, Doctor, for answering the question from Miss Agita, Boleh Indonesia. The Tuan Haji Rahman, yeah, you want to add some regarding this question?
I think it's well answered by Dr. Kemloy. It
I
depends.
think there's one from
The
Kala,
protections of
Yeah, Miss
UMD.
Kala.
What
Yeah, Miss Kala
question
got
you
two
want?
questions. Yeah.
Let me answer. Let's see what is the question. So, firstly, I do not understand what you meant by if we are ISO 37001 certified, do we need to register in MNCC? So, I'm not too sure what is the question. But the second question is that since the ISO 37001, there's a clause of whistleblowing requirement. Do we need to adopt the new ISO for whistleblowing, or is it sufficient within the current compliance? Now, under the ISO 37001, as it has been very clearly mentioned that under the clause 8.9, it's talking about raising concern, which is equivalent to speak up or whistleblowing. So that is already a provision for you to do. Our 37002 management system is the enhancement, which add in, to help you to have draft out a more robust and also a structured form of what whistleblowing mechanism is about. But in true cases, most of the company whistleblowing policy and procedure I have read is that most of them have combined the whistleblowing process and the investigation process together as one SOP. All right. So if you look into that, we have clause 8.9 called raising concern. We have clause 8.10 calling investigation. So it would be ideal for some of organization now, perhaps, if to have a whistleblowing policy and procedure as one, investigation SOP as another one, rather than to combine into as one. That is a different opinion. That is just a suggestion. So yes, it's up to you. You can enhance it, but ideally, what is this ISO is about? Basically, look into the clause 10.3, continuous improvement. There are room for improvement. Do not stay cast in a stone, but it's always improvement. So that is why we are going to come up with the ISO 37008 with internal investigation. Yeah. But at this moment, you do have your own investigation procedure, fine. But what we're developing more standard is to help to enhance, the need of these important processes that we want you to keep up to the latest methodology. Thank you.
Thank you.
All right.
Yeah. I'm sorry, I need to stop now because we are running late because.
Encik Swami, just sorry, one more from Miss Nur Husna. I think that's the last one. I think that all of them posted important question. Just a quick one, Dr. Lui or Tuan Haji, from Nur Husna.
From who? What's the question? Sorry.
Does the protection to whistleblowing includes technological protection? That is tracing of information via phone or laptop. Just a quick wrap, yeah. So at least we address all the questions.
Tuan Haji, you want to say first?
Okay. My opinion is that the effort to protect the confidentiality can include to that extent, but always it depends, as it doesn't one shoes fits all, and it depends, and we as the agency that's supposed to protect the whistleblowers, so we have to do so so that you remain confidential, and it means secret. But until now, we don't have any cases about the breaches or any disclosure of confidentiality regarding to the identity based on the tracing of the whistleblowers' phones and laptops.
My comment is that under the ISO 37002 whistleblowing mechanism, it's very important that we have to ensure a data protection right of the whistleblower, which also include things like, the IP as well. We need to trace that. Okay. So because data management system, including the system, security, retention, deletion, access, modification of personal identifiable information, and international data transfer, yeah, can be only accessed by authorized personnel during the investigation and not to be disclosed to other parties. That is the keyword: data protection and confidentiality. Thank you.
All right, it's time. Guys, have a pleasant weekend. Stay safe. For our Indian friend, happy Deepavali. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you.
Bye.
Stay safe, everybody.
Bye.
Wait for the budget this evening. All right.
Thank you for the reminder. All right,
Okay,
sure.
thank you. Okay.
Thank you, sir.
Okay.
Thank you.
Tuan Haji,
Bye-bye.
thank you.
Thank
Dr. Loy, thank you very much.
Thank you.
Thank you,
Bye-bye.
everyone.
Thank you, sir.
Thank you, everyone.
Best. Take
Have a
care.
good weekend.
Yes.